Yes, I was asked to be here, but the email did not contain any information of case or case number for the defendant. May I have that information, please?
My name is Nalia Carr.
I need somebody, I'm sorry, I need the person that needs, this is for the court clerk, and I need the name of the person that needs Spanish interpretation.
I don't need interpretation.
Right.
All right. Zero. I got one. I got.
Maria Cox?
Yes.
You're on mute.
Yes.
Can you hear me? All
I'm
right.
sorry. Yes, I'm ready.
The defendant's name is Julio, Julio. Last name Mejia, Mejia.
Okay.
The case number is 2356110. What else did you need?
That is all I needed. I also just needed to make you aware that I've been asked to help someone in a different court also. So I will stay here, but if I am momentarily unavailable, I may be helping in the other case in the other court.
Okay, because he's in jail on a tether violation. That's what he's here for today.
Okay. So
Okay.
whenever you need me, I will be here.
All right, thank you. Good morning. Anyone else need to check in that has not checked in?
I have not met Coral Watt appearing on behalf of, actually I did, I guess I did check in. I take it back. Miss McGee.
Yes, I have Miss Watt. Actually, you're on too. You're on Hobson too. Charles Hobson.
Yes. I do
Yes,
I need to send you a report. Can you put your email in the chat? Because we have a recent forensic center report.
All right.
And I have not checked in. Nalia Carr.
This is Mark Magidson. I'm Miss Carr.
All right, I have you checked in. Thank you.
Good morning. Do you have me checked in on Mr. Wilson?
Oh yeah, I have you checked in, Mr. Bitar. You're the first one.
Thank you. Good morning.
Good morning. You see my email, Ms. Watt?
Yes, I'm sending it to you now.
Okay. All right, and I got Carr. Anyone else need to check in that has not checked in? Oh, there's Kayla. Courtroom 233, Judge John's courtroom. Okay. Thank you. Good, how are you? What's Hood? You said it is exam? With Judge Giles? I didn't see a Hood with Judge Giles. We have a Brook bar at 9 o'clock. Okay, I can't tell you that, officer, that's up to the prosecutor. Sorry, Judge, were you ready? Dang, you ready before me?
It was like that's new.
All right, let me know when you're ready.
Hold on. Third Sixth District Court for the state of Michigan is now in session with the Honorable Judge Ronald Giles presiding. You may be seated.
You ready? Calling case number 2356228, the people of the state of Michigan versus Rashid Wilson. Defendant is charged with count 1, weapons, firearms, possession by a felon, count 2, weapons, ammunition, possession by a felon, count 3, weapons carrying concealed, count 4, weapons, felony, firearm, habitual offender, second notice. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Adam Woodcliff here on behalf of the 86266.
Good morning, Your Honor. Daniel Batar on behalf of Mr. Wilson, P62191. Mr. Wilson is present on Zoom.
Mr. Wilson, state your name for the record, please.
Hi, I'm Rashid Wilson.
Thank you, sir.
Rashid Wilson.
We heard you, got you. Okay. Mr.
Judge,
Batar.
we're asking the court to set this for an exam, please.
April 19th at 10 o'clock.
That works, Judge.
All right, anything else?
No, Your Honor. Thank you. See you then.
Thank you. All right.
Ms. Watt, are you ready on both yours?
I am. Did you receive my email?
No.
Okay, I'm gonna resend it now. But I am ready, yes.
Madam Clerk, if there is a new report, I haven't seen the other. If you could get a copy to it.
I will, yeah, absolutely.
Thank you.
Calling case number 2356178, the people of the state of Michigan versus Kayla McGee. Defendant is charged with count 1, police officer assaulting, resisting, obstructing, count 2, driving reckless, count 3, operating drag racing, count 4, operating no license, multiple licenses. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Adam Woodcliff here on behalf of the people, P86266.
And good morning, Your Honor. Coral Watt appearing on behalf of Ms. McGee, P41508.
All right, Ms. McGee on Zoom.
Yes.
Ms. McGee, I need you to unmute yourself. Turn on your video. State your name, please.
Kayla McGee.
Thank you. All right, Ms. Watt, we send this matter for exam.
Yes, Your Honor.
April 19th at 10:15.
May I check, Your Honor? Thank you.
Okay.
April 19th. I am going to be in a homicide trial that week. Is it possible to do the, like a Friday perhaps, or the following week? Would the following week work, Your Honor?
No, I'm not putting it off too far. I'll do it for the time.
I'm asking if the court would consider putting it off till like the 24th or the 25th,
21st.
the 21st. Okay, Your Honor. Thank you.
Oh, hold on. Give you the time.
Can we, oh, I'm sorry. I thought you were asking me, sorry.
21st at 10 o'clock.
Yes, I'll have to try and make it work, Your Honor. Yes. You don't have anything at noon, do you?
No. No.
No, okay.
I can do about 11. Would 11:15, 11:30 be better?
Yes. Thank you, Your Honor.
11:30. All right, anything else?
Nothing further, Your Honor, on this matter.
All right, that concludes the hearing. Bonds continue.
Thank you, Your Honor.
Okay. You sign out, Ms. McGee.
Okay.
Judge on Hobson is it's a competency on the docket. The clerk made an error for contempt.
Oh.
But it should, I know, I looked at it too. But it should be competency. So Ms. Watts sent a report. Did you want to look at it first? Or?
Is he on?
No, he's in jail. Did you want to wait for him? Oh, you
Yeah,
gotta wait for him. Oh, Ms. Watt, yeah, we have to wait for Mr. Hobson.
Okay.
The jail. They did call me this morning, so he should be coming out shortly.
Thank you.
You're welcome. So I'll just wait on that one then, Judge. Ready on Melvin Byrd?
Yes, Madam Clerk.
Calling case number 2259527, the people of the state of Michigan versus Melvin Byrd. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, malicious destruction of personal property, $200 or more, but less than $1,000. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Ed Booklet on behalf of the people, P86266.
And good morning, Your Honor, court staff, Jonathan Roberts, P86428, on behalf of Mr. Byrd, who is present on the Zoom. Mr. Byrd, could you please unmute and introduce yourself to the court?
Hi, my name is Melvin Byrd.
Byrd, sure, I don't do t-shirts in my courtroom, so when you come into court, please wear a shirt with a collar, all right?
Okay.
All right, thank you. All right, Mr. Roberts.
Yes, for this matter, we are still missing paper discovery. We did receive some video files, but we don't have the police report, the information, so we'd be asking for that. We would be prepared to set this for an exam date. I could just write up an order. I have a sentencing on the 19th, but I would be available anytime after 11 on that date. Alternatively, the 20th and the 21st are open for me, Your Honor.
Do 11 o'clock on April 19th?
Yes, Your Honor, thank you.
Okay, anything else?
Nothing from defense, Your Honor. Thank you.
All right. Through the hearing, the bonds continue.
Thank you, Your Honor. And Mr. Byrd, you can log off now.
All right, thanks.
Calling case number 235595202, the people of the state of Michigan versus Nalia Carr. Defendant number 2 is charged with count 2, assault with intent to do great bodily harm, domestic murder, or by strangulation. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Adam Bushbuck appearing on behalf of the people, P86266.
Morning, Your Honor. Mark Magidson on behalf of Ms. Carr, P number 25581. Ms. Carr, could you state your name for the record?
Good morning, Aaliyah Carr.
Carr, do you have video?
Ms. Carr doesn't have Ms. Carr doesn't have the video. She's at work right now, Judge. I have met with her, and she indicated to me she did not have video capability.
All right.
We would like to set this for an exam, but I would like to get the discovery on this case as well before the exam.
No problem. Counsel?
Oh, of course, Your Honor. Yes, it was sent, but we had a different attorney on the, our system. So I'll just make sure to send it to Mr. Magidson. I put his P number down. So I'll make sure to send it to him right away.
All right.
Thank you very much.
April 19th at 10:15.
Do you have something a little bit later, closer toward noon?
Okay, are we gonna go on the record or, okay, so just wait in the courtroom?
11:30.
See you then. Thank you very much, Judge.
You're welcome.
Yeah, I've got a 10 o'clock. Thank you, appreciate it.
All right.
I'll send the paper in the mail, okay?
Thank you very much.
All right, that concludes the hearing.
Thank you, Judge. Ms. Carr, you can log off now. I'll talk to you soon.
Calling case number 2356236, the people of the state of Michigan versus Brandon Baker. Defendant is charged with count 1, count 2, count 3, police officer assaulting, resisting, obstructing. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Adam Bushbuck appearing on behalf of the people, P86266.
Hi, good morning, Your Honor. Good morning to your staff. Neighborhood Defender Services by Ken Riggins, P82125, on behalf of Mr. Brandon Barker.
Barker or Baker?
I'm sorry, Baker. My apologies.
Sorry, Mr. Baker on?
To my knowledge, no.
Waiving his presence for the purpose of this hearing.
I will waive his presence, Your Honor. Thank you.
All right. We'll do so. Set this matter for exam.
Yes, Your Honor. I'm sorry. And I just wanted to ask the prosecutor if there was digital discovery. It seems like this happened in a casino, and I don't have any digital discovery. I do have paper.
I'll resend it, Your Honor. We did send, but I'll make sure we resend it, make sure Mr. Riggins gets it.
Thank you.
All right. 10:15 on April 19th.
I have a preliminary exam scheduled at that time. in front of Judge King. Actually, I have one client with 2 preliminary exams.
Eleven 45,
You said 1 or 11:45?
11:45 on April 19th.
That should work.
Anything else?
Nothing further, Your Honor. Thank you.
Here. Keep moving here.
Calling case number 23-56169, the people of the state of Michigan versus Kevin Marks. Defendant is charged with count 1, larceny in a building, count 2, assault or assault and battery, count 3, larceny less than $200, habitual offender, 4th notice. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Adam Bookbook here on behalf of the people, P86266.
Good morning, Your Honor. Neighborhood Defender Service by Cheryl Quick, P83973 on behalf of Mr. Marks. I do not believe Mr. Marks is logged on. I would ask the court to waive his presence for the PCC.
All right, waive his appearance for the purpose of this hearing. What's your pleasure?
Your Honor, we would ask to set this for a preliminary examination. I'd also request that the prosecutor, I believe that there's digital discovery. The paper discovery indicates that there's some video. I am not in receipt of that yet.
Yes, Ms. Quicks, I noticed that too, and I didn't have it, so I emailed my OIC. I'll let you know as soon as he uploads, sends it, or lets me know what status that is.
Very good. Thank you. And Judge, if there's anything available in the late morning on the 19th, I have a couple of matters across the street, but should be available. I would look after 10:30.
What about 11:45 on the 18th?
That's fine too. Yep, I'll take that.
All right. Anything further?
Nothing from defense. Thank you, Your Honor.
Thank you.
Good morning, the person on a device that says iPhone, what is your name? Good morning. Anyone need to check in that has not checked in? Your name that's on a device that says iPhone. Staying in Green Farm? I'm trying to find out who's on this iPhone.
The date of birth, bidding for a car.
Oh, yes, 2390.
2390. 2390. First name is Brooke. B-R-O. Warren. Warren. Is it 839?
No,
Well, yes, your client.
Oh, I'm sorry, you know what? I'm sorry, that's my fault. Oh, no, it's 624.95. It's a code deed. I'm
You
sorry.
got a different.
Yeah, it's a code deed.
It's not 620, what's it, 625?
624.1995.
241995. No, they have a bar on it, but it's not the right girl bar. Yeah, they have a middle. And it's a different birthday. Yeah. All right, let me call you back, all right?
I know they having some computer,
Yeah,
problems over there.
you checked it out. You don't have a bar. It's not, don't have the same birthday.
Maybe she's got, let me look at her, let me look at her retaining sheet. Nope, it just says one birthday on here. One name, she don't have an alias. I was gonna say, they called me this morning, but
They brought some Christmas.
they could have had.
That is 95, and she was born in 95. It sounds familiar. Same birthday they got.
95, but it's a different date.
That might be.
Also, they do have 95, but they have.
That's a clerical error, because it's the same person. I can't imagine they
How
ever
does
would want to vote for her.
Is she black, female, white,
Right.
female?
White female.
She's
White,
white.
female.
They have, on my investigative report, it's June 24th, 95.
Yep, that's on the retaining sheet too. All right. Oh, the iPhone hung up, huh? Yeah.
Yes, it's during the 36 district court. Yeah. Hey, yes, okay, I called earlier. Oh. Yeah, it's 36 district court. I called her. Okay. My name's Lauren. 6, 4, 5. I guess she is that white female. Yeah, that's probably the technical. That's probably the same one. What are we doing with it? Do we need to come over? Or we
Yeah,
need to
it's
put it on
it's
Zoom?
in.
It's a dismissal.
Pull on her over right
Or
there.
Johnny.
What?
It's gonna get dismissed.
Okay, can you have it put on Zoom because it's gonna get dismissed? Okay. Okay, we have enough.
I'll put it on Zoom.
I'm calling the Zoom.
I ain't worried about it. I can do it all.
Oh, okay.
I know where she is.
Okay.
so
Okay. All
I
right.
like to just show up.
Okay, I didn't know it was your training. All right. Well, yes. Oh.
We ready? Ready on fire, just?
Yeah.
Calling case number 23-55792, the people of the state of Michigan versus Brooke Farr. Defendant number 2 is charged with count 4, weapons, ammunition, possession by a felon. Count 7, police officer assaulting, resisting, obstructing. Habitual offender, second notice. This matter is scheduled for examination.
Good morning, Your Honor. Ed Woodcock, three on behalf of the people, P86266.
Good morning, Your Honor. Good morning to your staff. Ted Wallace, P8092 on behalf of Ms. Farr, who I don't know if she's present on Zoom, but if she's not, I would ask for the waiver presence for this hearing.
She's in the Wayne County Jail, waiver of parent for this hearing. Yes, Your Honor, today's the date and time set for examination. Key officers have failed to appear. My officer in charge has indicated that she will reissue the case, but we are unable to proceed today.
Defense moves to dismiss, Your Honor.
No, this is.
Thank you.
Yes, dismissal form, please.
Yep.
Good morning. Anyone need to check in that has not checked in?
Good morning. I'm Sophia Nelson of NDS. I'm here on the Julio Mejia bond hearing.
Oh, okay. We're waiting on him. The interpreter is on. We're just waiting on the jail to put him on.
Thank you.
Oh, I want to do, here's Wayne County Jail now. Good morning, Wayne County.
Good morning.
Who do you have?
You have Mr. Hobson, Ms. Fair, Mr. Julio Maja. Anyone want?
Okay, Ms. Farr, we already did her case. Her case was dismissed.
Dismissed. Ms. Farr, okay.
No, he was giving it. He was just telling me who he has. So we got Hobson. Did you read the report, Judge? Hobson? No. And we got Mejia, that is a tether violation. You want Hobson first or
Yeah, we do Hobson.
Wayne County, can you put Hobson on first and then Mejia?
Yes, ma'am. Can you give us 2 minutes?
Thank you. Maybe when you're done with Mejia. See. Has he seen her before?
Have you seen which part? This one? No, I haven't seen her since the last time.
Yeah. Oh, she's young. Because they have different birth dates on there. You sure you don't want to make sure, because we have the birthday on this dismissal? Good?
Yeah, we're good.
I'm gonna go out on a limb and say there's not too many Blonde hair, bush fires over in the wing.
Who wants it darker?
You can fill in the gaps everywhere else that I'm putting on that, but.
Hey.
Yeah, thank you. Have a good day. You too.
Which one is yours?
Yeah, no, no, it's great.
All right, very much.
Yeah.
Okay. Yeah.
Today's 12.
Yeah. Yes, unless you watch it practice. Yes. Absolutely. Sergeant. Yeah, he did. He said 2 minutes. Oh, yeah, that he was right with him. we go. Wayne County Jail, your name?
Charles Hobson.
All right, thank you. Ready, wait. Ready, Judge?
Yeah, I'm ready.
Calling case number 2261907, the people of the state of Michigan versus Charles Hobson Jr. Defendant is charged with count 1, assault of prison employee, habitual offender, for notice. This matter is scheduled for a competency hearing.
Good morning, Judge Alex Swing, on behalf of the people, P number P86590.
And good morning, Your Honor. Coral Watt appearing on behalf of Charles Hobson, P41508.
Thank you. Mr. Hobson, can you state your name for the record, please?
Charles Hobson, HOBSON.
Thank you, sir. All right. Court's in possession of a document on the letterhead of Department of Health and Human Services Center for Forensic Psychiatry dated March 13th, 2023, and authored by Benjamin Ligerte, that's L-A, capital L-I-B-E-R-T-E, PhD, licensed psychologist. All parties have seen the document.
Yes,
Are you stipulating to the results?
yes, we stipulate to the results.
Yes, Your Honor. Stipulated.
All right, the end result is that the doctor found Mr. Hobson at this point competent to stand trial. So we're gonna, court's gonna find him competent, and we're gonna move forward with this matter. Set it for preliminary exam. Ms. Watt, when did we set your other one?
On the 21st, Your Honor.
We set that one for 11:30, right?
Yes, Your Honor.
Why don't we do 11:45 for this one?
Thank you, Your Honor.
All right, anything else?
Nothing further, Your Honor. Thank you.
All right, that'll conclude the hearing.
All set, Your Honor?
We're all set, Ms. Thompson, thank you. We'll be back on April 21st, next Friday at 11:45 for your exam.
Okay.
All right, thank you.
Exam?
Yeah, that's the preliminary exam.
Wayne County, are you gonna put Mr. Mejia on? Oh, yeah.
Madam Clerk, this is the interpreter.
Yes.
I may need 5 or 10 minutes to finish the case in the other court, but I should, hopefully it'll be just about 5 minutes or so.
Yeah. It's probably gonna take him about 5 minutes to bring it.
Madam Clerk, we actually scheduled that other exam for 11:30, not 11:15.
Oh, that's fine. We're all right. Just do one
Okay.
after the other.
Okay, so it's okay that it's 11:45?
Yes.
Okay, just checking. Thank you.
Yeah.
Okay.
Oh, Ms. Cotton? Oh, she might be
She couldn't come
gone.
back until she said.
Yes.
He's on.
Oh, okay. Let me see.
Hey.
Just a second. I will be right with you.
Your name in Wayne County Jail?
Excuse me, Judge Grant. I need about 5 minutes. They just called me to the other court. The defendant is present. It shouldn't take very long, but I will be right back. Thank you.
Nelson. Attorney Nelson, are you ready?
Yes.
Oh,
I am ready too. Thank you. ¿Usted es el señor Julio Mejía?
Claro que sí.
Okay, he said that that's him, Julio Mejía.
Are you ready, Judge?
Yeah.
Oh. Calling case number 2356110, the people of the state of Michigan versus Julio Mejia. Defendant is charged with count 1, malicious destruction of personal property, $1,000 or more, but less than $20,000. Also calling case number 2356106, the people of the state of Michigan versus Julio Mejia. Defendant is charged with count 1, malicious destruction of a building, $1,000 or more, but less than $20,000.
Llamamos el caso del estado de Michigan contra Julio Mejía, el caso 2356110, destrucción maliciosa de un objeto de valor de más de $1,000, pero menos de $20,000. Y el cargo número 223566106, los mismos cargos, destrucción de un edificio o estructura que vale más de $1,000, pero menos de $20,000.
Good morning, Your Honor. Adam Bookful appearing on behalf of the people, P86266.
Y se presentó y dio el número de la licencia el abogado acusador.
Good morning, Your Honor. Sophia Nelson of Neighborhood Defender Service on behalf of Mr. Mejia, P77960.
Y la señorita Nelson se presentó que lo está defendiendo a usted y dijo que trabaja para la Oficina de Defensores Públicos, dio su número de su licencia.
Ms. Cox, can you put your appearance on?
Maria Cox, State of Michigan, Qualified Spanish Interpreter.
All right, raise your right hand. Do you swear or affirm the translation of Spanish to English, English to Spanish to the best of your ability?
I do.
All right, thank you. All right, Ms. Nelson, this matters for a tether violation. What are we doing?
Your Honor, these two tether violations, Mr. Mejia was placed on house arrest. He was released with the instructions from DDC in English. He does not speak or read English. The tether violations occurred prior to the PCC in this case, where he was leaving his house to get tools for his job. He did not go to the complainant's address or anywhere near her address. At the PCC, through the interpreter,
What we're doing, I don't need to know the whole story. Just what are we having a hearing? Are you pleading guilty? What are we doing? That's all I need to know at this point.
he is guilty of the violations, Your Honor, but it's complicated because it wasn't knowing or willful because he didn't know what the restrictions were because they were given to him in English.
No, please, if you just answer my questions, we get through this much quicker. I'll give you the opportunity to explain. But you're telling me that he's guilty, so he's gonna plead guilty with some type of explanation, then you're gonna give me that, is that correct? Well,
Yes,
I have
Your
to do it in a certain order, okay? So, all right, is that how we're proceeding?
Yes.
Thank you.
Your Honor, may I translate that for Mr. Mejia?
Yes.
Estaban discutiendo su abogada y el juez. Ella estaba diciendo que usted sí cometió esas infracciones contra el grillo o el aparato que tenía, pero fue porque le dieron las instrucciones en inglés y usted ni habla ni lee inglés. Y eso sucedió antes del PCC, pero usted se va a declarar culpable y están pidiendo una audiencia y explicar qué pasó.
All right. Yes, please state or raise your right hand.
Señor Mejía, por favor, levante su mano derecha.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, self you got?
¿Usted afirma o jura que va a decir la verdad y nada más que la verdad? ¿Lo jura?
Sí.
Yes.
Sí.
Yes.
Yes.
All right. You can put your hand down.
Puede bajar la mano. I think he's frozen, Your Honor. This is the interpreter. Okay.
Okay.
Here we go.
All right. So Mejia, you were placed on the Wayne County Sheriff's Tether program on March 30th, 2023. Is that correct?
Usted lo pusieron en el programa de vigilación en marzo del 2023, ¿verdad? Señor Mejía, ¿sí o no?
No, verdad no, yo no entendí cuando me explicaron y sí, yo salí, pero fue a buscar mi trabajo porque pues no tengo 3 hijos y una casa que mantener. Yo no entendí bien cómo eran las reglas.
Your Honor, he's saying that he did not understand the instructions, that he did leave the house, but it was because he needed to do some work or look for work. He has a house and 3 children to maintain.
I understand that. I just need him to answer my questions right now. You'll have an opportunity to explain.
Él dice que le da una oportunidad después de explicar, que por ahora nada más conteste sus preguntas.
He was placed on the Tether program on March 30th, 2023. Is that correct?
Lo pusieron en el programa que le pusieron el GPS en el tobillo el 30 de marzo, ¿correcto?
Sí.
Yes.
All right. You were given rules and regulations of the program, but you were given those in English. Is that correct?
Le dieron a usted las instrucciones y pues leyes de ese programa, pero se las dieron en inglés, ¿correcto?
Todo me dijeron en inglés, pues, y no entendí muy bien.
Yeah, everything was given or said in English, so I didn't understand very much.
Pues, porque no entendía.
So I did not understand.
On April 5th, 2023, you left the home at 7 o'clock in the morning.
El 5 de abril, ¿usted salió de la casa a las 7 de la mañana?
El 5 de abril.
I'm sorry, Your Honor, you were speaking at the same time.
Fue mi corte.
Perdón.
A las 7 de la mañana.
¿A dónde fue?
On April 5th.
¿A dónde fue el 5 de mayo?
El 5 de abril fue mi corte y sí salí a la... Sí, porque vine aquí a las 7:20 a registrarme el grillete. Sí, salí a la mañana para venir aquí.
Yes, I did leave that day at before 7:20 because that was the time that I had to come get the tether. So I did leave at that time, that day. It was one of my core days, he says.
On April 2nd, you left his home at 12:32 a.m. and didn't return until 2:15 a.m.
El 2 de abril, usted salió de la casa a las 12:32, la medianoche, y no regresó sino hasta las 2:15 de la mañana. ¿Correcto?
Sí.
Yes.
Sí. Yo yo fui a donde trabajo porque hicieron una fiesta.
He said he went to his place at work.
Me llamó mi jefe para que fuera a recoger comida para mí.
Your Honor, he's breaking up, but he did say, and I got the first part where he said that he left to go to his place of work.
Dice,
Where does it work? Where was he working?
Y fui a...
Just wait, yeah, hold on.
Momentico.
Where was he working?
¿Dónde estaba trabajando? ¿A qué lugar fue?
Ahí es un lugar donde hacen fiestas y fui porque mi jefe me llamó porque quiere que le cambie el cielo falso y le la puerta. Entonces fui a buscar un contrato y mi jefe me llamó porque hicieron una fiesta y me regalaron comida para mis hijos y para mis perritos. Entonces fui a buscar un contrato de trabajo y comida y regresé. Nomás fui a buscar la comida y regresé. Sí, es cierto.
Your Honor, he works at, it was at a banquet hall where they had a function, and they want the ceiling work done and the doors. So he went there to get a contract from them. And while he was there, they gave him some of the leftover food for him and his children to eat.
Where was that at?
¿Y en
What's the
dónde
address?
dónde es ese lugar que hubo la fiesta?
Es un lugar donde hacen fiestas, se llama Capi.
¿Capi?
Así se llama, es un lugar donde hacen fiestas.
Yeah, it is a banquet hall where they have parties, and the name is Capi.
Where is it?
¿En qué ciudad? ¿En qué lugar? ¿Tiene la dirección o sabe por dónde?
Es en Detroit,
It is in Detroit.
En la calle La Green.
La Green, the street is, and the La Green Street in Detroit.
Yeah.
Okay, another day he went to Lincoln Park. Where did he go there for?
I'm sorry, Your Honor, would you repeat the question?
On another day, or it might be the same day, he went to Lincoln Park.
Dice que cree él que el mismo día o tal vez un otro día diferente usted llegó hasta Lincoln Park.
Sí, yo también fui a ese lugar porque yo hago, como le digo, yo hago trabajos. Entonces ahí solamente fui a traer unos porque me unos barriles para quemar basura porque pues trabajo y tengo que trabajar.
Your Honor, he broke up in the middle of it, but I did understand that he said that he went there for work also, and that it had something that it involved garbage barrels, but that he was there for work.
Solo me tardé como 10 minutos, solo fui y regresé.
That only lasted about 10 minutes, then I went back.
All right. Anything else, Ms. Elsa? You want to ask or add?
Yes, Your Honor. Mr. Mejia lives in a home without running water. He's a contractor. He works on various homes, rehabbing them, specifically people buy land bank homes or other dilapidated houses, and he helps fix them up. He's fixing up his own home. I don't think a home detention tether under those circumstances, one, he needs to work to provide for
I'm
his
not
children.
addressing the bond conditions. I'm addressing the violation of bond.
Okay.
That's what we're here for.
The bond violation, Your Honor, I would
Ms.
just.
Nelson, may I interpret for Mr.
Yes.
Mejia? El señor le pedí a la señorita Nelson que me diera tiempo para traducirle a usted. Ella dice que usted vive en una casa que no tiene agua corriente, no sale agua, y que entonces ella no cree que poniéndole un grillo sea algo justo para usted. Usted es un señor que trabaja, usted trabaja arreglando casas, usted está arreglando su propia casa, usted mantiene una familia. El juez la interrumpió y dijo que lo que están hablando ahora es sobre la fianza.
While Mr. Mejia is technically guilty of these tether violations, we asked the court take into consideration that they were provided to him in English. He did not understand them, and that he did not do anything nefarious while traveling. He did not go anywhere near the complainant's home.
Y yo quiero decirle a la corte que mientras aceptamos que el señor Mejía es culpable de esas infracciones, que por favor piense o reconsidere que las instrucciones se las dieron en inglés, no las entendió. Él cuando salió no hizo nada malo y nunca estuvo cerca de la casa de la persona que lo acusa.
People wish to be heard. Only to state that as an immigrant myself and English my second language, I'm deeply sympathetic to the argument, and I have no objection, but I'll leave it to the court's discretion as to what you do.
El abogado fiscal dice que no tiene ninguna objeción a lo que están pidiendo y que lo deja a que decida el juez.
All right, Nelson, you get the last. Anything else? You get the last rebuttal if you want it.
No.
¿Algo más que usted quiera decir, señorita Nelson? Ella dijo que no.
All right, I understand early the language barrier there. I understand that he may not have understood the conditions of his requirements for his tether. I'm not buying the part that he went there at 2 o'clock in the morning to get a contract. You know.
El juez dice que él entiende que usted le dieron las instrucciones en inglés y no la entendió, pero lo que no cree es que usted fue allá a la medianoche a conseguir un contrato.
Yo tengo pruebas.
I didn't ask him to say anything. Just tell him, don't say a word.
No diga más nada.
All right, but I am going to reinstate his tether and allow him to go back home. He is on house arrest, which means he does not leave that home, period, unless he is coming to court, going to the hospital. It's an emergency situation.
Your Honor, may I interpret that,
yes.
please? Okay, el
Yes.
juez dice que va a poner otra vez que le pongan el grillo o el GPS y que le van a poner lo que se llama arresto en casa, lo cual quiere decir que no puede salir de su casa a menos que sea a la corte o una emergencia que necesite ir a un hospital o ver a un médico.
All right. Nelson, if whatever reason you want to attempt to change the conditions of his tether, then I need to. Wow. To leave.
What do you need?
Yeah, I need to file. Who else lives in the home with him? You know, Nelson?
I believe his children, but let me check. Who else lives in the home?
¿Quién más vive en la casa con usted, señor Mejía?
Solamente vivo yo.
It's just me.
I would just note, Your Honor, that there's no running water in the home.
Yo quiero que usted considere, señor juez, que no hay agua en esa casa.
¿Puedo decir algo?
May I say something? Said Mr. Mejía.
Not yet, unless his attorney wants him to say something.
Ahora no, a menos que su abogado quiera que usted diga algo.
1 second, though.
Un momentico.
Yeah.
All right. The, an opportunity to review the register of actions that, Mr. Mejia was put on tether by the magistrate.
He tenido la oportunidad de revisar las notas de este caso y un magistral puso al señor Mejía con ese grillo.
Because he was out on bond, this matter was never reviewed by a judge.
Pero como él estaba fuera bajo fianza, nunca la vio un juez.
I mean, he's charged with a non-violent offense that is basically probation. I mean, I don't.
Y los cargos en su contra no son un crimen violento, el cual puede decir que entonces nada más le den libertad condicional.
You know, I'll give both opportunity. I give both parties an opportunity if you want to argue, but I don't see a reason for the judge.
Dice, yo le voy a dar una oportunidad a los dos abogados a que expongan lo que quieran decir, pero yo no veo la razón para que él tenga que tener un grillo puesto.
I have no objection to the removal of the tether, Your Honor. I'll just leave it to your discretion.
All right.
El abogado fiscal dice que él no tiene ninguna objeción a que le quiten el grillo.
Ms. Nelson, I assume you have no objection also.
No objection, thank you.
Y su abogada defensora dice que ella tampoco tiene ninguna objeción.
All right, then the court's going to remove the requirement of the tether. Nelson, I'm going to need an order for that. You can send that in to us, I'll sign it, we'll send it over to the tether department, and they can, well, actually, don't know.
Señor Mejía, el juez va a ordenar que le quiten el grillo y le pidió a la señorita Nelson que le mande una orden para mandársela a donde lo ponen para que se lo quiten.
Other than that, his bond will be reinstated, just removing the tether requirement. Mr. Mejia, you can still have no contact with the complaining witness and no contact with the address of 1689 Glen Court in the city of Detroit. Do you understand that?
Ok, señor Mejía, le van a quitar el grillo, pero dice el juez que todas las demás regulaciones o reglas de su fianza siguen vigentes, sobre todo que no puede tener contacto con la persona que lo acusó y que no vayan ni cerca de la casa que queda en 1689 Lynn Court. ¿Entiende?
Sí.
Yes.
All right. With that, anything else?
¿Algo más?
Muchas gracias, y todo esto pasó porque yo no entendí y sí tiene razón el juez. Yo salí a las 2 de la mañana, a las 12 porque terminó la fiesta, entonces yo fui a recoger la comida y a la vez me dieron trabajo.
Yes, Your Honor, I understand that I did do wrong, but I left my home at 12:30 because they had called me that the banquet was over and they had food for me and my children, and I did get a job contract.
All right. Anything else, Ms. Nelson?
No, thank you, Your Honor.
Okay, ya
Yeah.
terminamos. Su abogada dijo ya no es más nada.
All right, that concludes the hearing.
Thank you, Your Honor.
You're welcome.
Have a good day.
You too.
So the attorney sent over an order.
Oh, so. Asked you to.
Wayne County Jail. Thank you, we're all set. All right. Parties ready on Robin Hubbard. Calling case number 2355962, the people of the state of Michigan versus Robin Hubbard. Defendant is charged with count 1, controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams. This matter is scheduled for examination.
Good morning, Your Honor. Ed Bookman appearing on behalf of the people, P86266.
And good morning, Judge Hannah Barron, P85265, representing Ms. Hubbard.
Well, I need to state your full name for the record. I need to stand up, please.
Robin Hubbard.
All right, you ready to proceed?
Yeah, there was a pre-exam offer to reduce count 1 to misdemeanor use of cocaine. It's my understanding that Mr. Hubbard would accept that.
Motion.
Yes, Judge, that's right.
So she's accepting it.
Yes.
So I need you to raise your right hand. Well, first of all, Ms. Hubbard, are you high?
No, I'm sleeping, I was tired, I work. I haven't slept in 2 days, really. And so bring my hand.
So if I send you down and have you tested right now, you're gonna be clean, right?
I'll be clean at the end of the day.
I didn't ask you if you'd be clean at the end of the day. You'd be clean right now if I send you down and have you tested.
Can I talk with Ms. Hubbard?
Sure. Sure.
Oh, sorry.
On this way. She's high, I can't take it. I don't know how drugs influence her. I don't understand what she's doing.
Could we set a different date?
I'm gonna set a different date.
Okay.
I'm gonna make sure she's not. I'm gonna take a bye.
Today?
Today.
Is there anything that would change that for the week?
Ran back out here. She walked in. I knew she was high. Fortunately, 4 hours later, I worked in Detroit East.
So there's nothing we can do on the for that.
No, I want to make sure she's clean when she comes in. I want to go and eat it.
Is that like a pretty good date?
Yeah, I'll set it tomorrow. She should, I feel good.
Yeah.
Tomorrow, I should be out of Tether. You know, I have to, I can't take it.
Okay, and if we just hold the exam, just go.
At this point, I don't see how she can assist you. I don't see how you can say, I want to do this exam, and you know you're trying to. I mean, I'm just, I don't really do that on the record.
All right, yeah.
But if I have to.
We're ready to go back on record.
All right. Back on the record, in case number 2355962, people state of Michigan versus Robert Hubbard. No opportunity to speak to your client.
We did, Judge.
All right. I can't proceed with this hearing when your client is under the influence of drugs. It's obvious to the court that she can't even stand up. I'm not asking you to say anything now. So I'm gonna put this over. I'm gonna put it over to tomorrow. It's not gonna feel good, but it'll be out of the system. All right, I can tell no she'll not be under the influence. So, and her bond is now going to be modified to 30,000 cash.
Judge, I have no objection to this being set over to tomorrow. I do object to her bond being raised. Ms. Hubbard is not endangering the community. She's not a failure to appear. She's here today. So I
Client's under the influence of drugs. She's coming to court high. She came here with the intent on pleading guilty. I can't take a plea from her if she's high. So it's the equivalent of not being here, period. So I understand your objection. Trust me, I do. But I want to make sure that she's not high when she's standing in front of it.
And Judge, Ms. Hubbard understands what probation would be. She understands that probation would require that She does not do drugs. so-
Counsel, we're not even that far. We can't get that far. I don't know what she can understand when she's high. She's barely standing there now. So at this point, 30,000 cash bond. We'll be back tomorrow morning. We'll do it at 8:30.
Here you go. Thank you, Jack.
I need to.
Like, Attorney Hamilton in. On PCC.
Yeah, I got a hearing on discovery, but she's next. Huh? Did she come? No, she did. She showed us. Who? Yeah, they're, that's her. That's the attorney on the
Same one.
So that case is, remember the discovery order? The attorney submitted a discovery order and the prosecutor would sign off on it.
Oh.
So I seen she was already on the docket, so I put it on.
Okay.
On that. All right. Ready on Buford, parties ready on Buford. Calling case number 2356139, the people of the state of Michigan versus Roy Buford. Defendant is charged with count 1, assault with intent to murder, count 2, assault with intent to do great bodily harm less than murder or by strangulation, count 3, weapons, ammunition, possession by a felon, count 4, weapons, firearms, possession by a felon, count 5, weapons carrying concealed, count 6, assault with a dangerous weapon, felonious assault, count 7, weapons, felony, firearm, count 8, weapons, felony, firearm, count 9, weapons, felony, firearm, count 10, weapons, felony, firearm, count 11, weapons, felony, firearm. This matter is here on the discovery hearing. Howard. Yeah, Howard is here.
Good morning, Your Honor. Ed Bookbook here on behalf of the people, P86266.
Good morning, Judge Hannah Barron, 85265, representing Mr. Buford. And waiting his appearance for today's purposes.
I am waiting for purposes here. This is an issue regarding a discovery order that was presented.
Yes, Judge, and I'm not sure, and I was just notified this morning that this was put on, so I'm not sure if this is, I guess, my motion right now, but I did send over a discovery order to the court. There's specific discovery in this case that indicated throughout the police reports as existing, and I don't have that discovery. Specifically, I don't have any body worn camera of the stop and arrest of my client. And the police reports indicate that this would come from officers Houston and Murray. And the police reports further indicate that they had their body worn cameras on. Those cameras were activated. So I'm unsure why we don't have that. And then more than that, Judge, the complainant made a statement, and reports indicate that, specifically indicate that that statement was recorded on Officer Mason's body worn camera. We don't have that body worn camera either. So we don't have this recording of a statement that all the reports indicate does exist.
Okay. All right, so just so you understand why we're here. Whenever you send in a discovery request, and it's not on a standard scale form, I give this request to the prosecutor's office first to make sure that they are, they agree with it. Okay, evidently they didn't agree with something, which is why we set the hearing.
Understood, Judge.
But no, I understand your argument. People wish to be heard.
Yes, Judge. Ms. Barron and her client are completely entitled to the body worn cameras. And if she hasn't gotten that yet, I apologize. Definitely make sure to send that over. My colleague did just check an email chain with the officer in charge in this case, and she notified us that it does exist and it was uploaded, so we will make sure to send that over. Our only issue was with the criminal record and the prior convictions of the victim, in this case, Mr. Cleaves. We don't have any of that information. And even if we did, Your Honor, I don't believe it would be relevant in this case. And I definitely can't turn over any lien information on Mr. Cleaves. But essentially, we don't have it. It doesn't exist, and it's not something that we will be able to turn over. And that's essentially the second half of prong number 4 in Ms. Barron's argument. The first thing, with anything having to do with Brady violations for police officers, definitely we would send a protective order to the court, have that signed, and then turn that evidence over to Ms. Barron and her client. But anything pertaining to the civilian victim in this case, his criminal records, I don't believe they're relevant, and even if they were, Your Honor, I don't have them, and I can't turn them over.
Judge, that would be exculpatory evidence, evidence of prior acts of violence from the complainant. That would be exculpatory evidence in this case.
Required by law. I mean, you're asking him basically for lien information. He can't give it to you.
Information specifically from lien. I understand that the prosecutor never turns over lien information straight from lien, but they can put that into, or they can make that into a document that would be discoverable. Just anything other than lien. The information is discoverable.
Okay. Well, I don't know that the information is discoverable. One, that I am not positive of. And 2, is not needed for example. So I'm gonna scratch that part off of your discovery request. And you can make that request if it gets sent across the street. All right?
Understood, Judge. So just those specific body worn cameras were just uploaded?
Yes, we did just check the Axon report. It was sent on April 10th. I'm not sure if it's an indicated download or not, but we're going to resend it just to make sure to avoid any complications or any maybe like computer glitches.
Okay.
All right. So again, I'm scratching the last part of that line off where it says any evidence, previous violent acts or threats made by the complainant, and initialed off, other than that, of signing the discovery order.
Thank you, Judge.
Thank you, Judge.
Just wanted to know if I had some other option before.
Yeah.
I would do that.
Yeah.
You know, this kid, you know, I'm just, no. Yes, please.
There is an attorney here that for DCC, on, Indiana.
Oh, yeah, Hamilton. Your Honor, but you know, they came in person for the BCC. That's Miss Hamilton, and, okay, yeah. Yeah.
Are they in a home? Oh, they
Want me to get them now?
No, we'll do her. We'll do this one then. Good morning.
Good morning. How you
Good
doing?
morning. How are you?
Okay.
So good to see you guys again.
Huh?
It's so good to see you guys again.
Thank you. Good to see you too.
Calling case number 2355660, the people of the state of Michigan versus Edward McCall. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for examination.
Good morning, Your Honor. Adam Book, appearing on behalf of the people, P86266.
And good morning, Tiffany Hahn, on behalf of Mr. McCall, P79667.
Sir, state your name for the record. McCall, you don't know how to address the court. I didn't ask for your apology. I said you knew how to address the court.
Yeah.
I didn't.
I'm currently going to something.
I beg your pardon?
I'm currently going to something right now. I didn't have clothes for, so
I have no idea what that means.
I don't have clothes basically for that attire.
I have a shirt with a collar.
So what's that?
You don't have a shirt with a collar? You do?
Yeah.
What I asked for. Normally I would just. Only collar the shirt I allow in my courtroom. I'm from Wayne County Jail. I assume you don't want that one. You know, so we understand, you know, it's a matter of respect. A matter of respect in the court. You want to be respected, right? So do I. Okay? All right. You ready to proceed?
Yes, Your Honor, people are prepared to proceed.
Yeah.
Before we begin, just ask for mutual sequestration of all witnesses, Your Honor.
No objection?
No.
All right, you know, witnesses testifying today at trial, anytime in the future must leave the courtroom or be denied that future testimony. All right, proceed.
Thank you, Judge. People would call police officer Lemire Downs.
Thank you.
Step up here, please. You raise your hand. You swear our affirm that the truth, truth, and truth, and truth. Yes, sir. All right, put the door towards you.
Thank you, Judge. Officer, could you please state your name for the record one more time?
Lemire Downs,
And Mr. Downs, where are you currently employed?
12 Precinct, Church Police Department.
How long have you been with DPD?
Approximately 4 years.
I want to direct your attention I want to direct your attention back to February 20th of 2023. Were you in the area of Fenkel Street and Green Lawn Street?
Yes,
Is that in the city of Detroit, County of Wayne?
yes,
Were you working that day?
yes, I was.
Did you see anything that might bring us into court here today?
Yes. Explain.
Briefly.
Yeah, we just observed
No,
I
proceed by question and answer,
Question.
and it's not what we did. You're going to testify what you did.
right.
Let me do a better job here. My apologies. Were you working alone or with a partner that day?
I was working with a partner,
Okay. What's your partner's name?
Officer Criswell.
Were you in uniform?
Yes,
Or were you on foot or were you in a car?
patrol in a car.
So what do you observe on Fenkel and Green Lawn Street?
Observed the expired tag on a Ford Edge.
On a Ford Edge? What do you mean by expired tag?
So the tags now, being that the color is different per year, observe what I perceive to be expired tag, and
So let me clarify, are you driving or are you in the passenger?
I was driving.
So your partner's in the passenger seat?
Yes, he's the lead operator.
So what do you do when you see the expired tag?
Actually, I just informed my partner and he took it from there as far as doing the lien.
Okay, so your partner does a lien, don't tell me what it says, but you observe and do a lien?
Yes.
Okay, so what do you do next?
We initiated a traffic stop at Finkel between Roselawn and Greenlawn.
And what happens when you initiate the traffic stop?
As I'm exiting the vehicle, I could observe the driver reaching with his right hand towards the rear.
How many people were in the car?
Just one. One occupant.
Just one occupant? And where was he located?
Driver's seat.
What time of day was this?
It was approximately 4 o'clock, I believe, midday actually.
In the afternoon. So was the sun out at the time?
Yes.
Did the Ford Edge have tinted windows?
I do not recall there being tinted windows. I think the rear possibly slightly. I don't recall if it was tinted.
So, okay, so you observe the driver reach back into the back is what you said, is that correct?
Yes.
So what do you do when you observe that?
We started walking up to, I started to walk up to the driver's side of the vehicle. I informed the driver of why we initiated a traffic stop. As I informed him why the reason we initiated a traffic stop, I could observe my partner trying to inform me that he observed. He was like pointing down.
For the record, the witness has his hands about in his torso and he's pointing down. So that's what your partner was doing?
Yeah.
Okay. So, the driver of that vehicle, do you see him in the courtroom here today?
Yes, sir.
Could you please point to him and identify him by an article of clothing?
Yeah, he's wearing a black shirt, white writing on it, with dreadlocks.
Thank you, Your Honor. May the record reflect that the witness has identified the defendant. So you inform him of the traffic stop. Does he say anything to you at that time?
Not too sure as of what he said initially after I informed him of traffic stop, but I did ask him if he had any weapons in the vehicle, and he did state to me that he did.
He stated to you that he did have a weapon in the vehicle?
Yes.
Okay. So did you at any point ask for any ID, proof of insurance?
I asked him if he had a valid license. He said he does not have a license.
Okay. So what do you do when you find out this information?
After asking him if he had any firearms, and he stated to me yes, and he said it was in the glove compartment. Then I asked him to step out of it.
Okay. And what do you do when you ask him to step out of it?
I detained him, walked back, and then after he was with my partner, I did recover the firearm from the glove compartment.
Okay. Did you recover anything else from the vehicle?
Yes, I recovered a magazine that was in the rear.
That the same object you observed him throwing?
What I believe, yes.
Did Mr. McCall provide a concealed pistols license to you?
No. Only registration for the fire.
What if anything happened next?
We transported to the DEC after informing them that he was arrested for carrying concealed.
Forgive me, one last question. Forgive me if I already asked it. What kind of weapon did you recover from the
I
car?
recovered a Glock, I believe it was a 43X from the glove compartment.
No further questions, Your Honor.
Yes. Good morning, officer.
Good morning, ma'am.
You stated that when you approached the vehicle, you observed Mr. McCall. What did you observe?
So as I exited the vehicle, I observed Mr. McCall reaching with his right hand towards the back of the vehicle.
Now, is that movement along illegal?
No, it's not illegal.
Okay, so there's nothing wrong with someone moving in the vehicle, correct?
No, ma'am.
Okay. What else did you observe?
He then let down the window, just came back and it was, I just performed a normal traffic stop.
Okay, so you didn't observe anything in his hand?
No.
Okay. So he then rolls down the windows, and at this point, you have a conversation with him regarding this traffic stop.
Before that, are you asking when I walked up to the vehicle, did I observe anything in his hand?
Yes.
Or when he reached in the back?
Well, at any point, did you observe anything in his hand?
I observed something in his hand as he was reaching in the back, yes.
Okay, so where were you when you made this observation?
I was exiting my scout car.
But where were
Behind his vehicle.
I'm sorry?
Behind his vehicle.
So you were standing behind his vehicle. So which window did you see this through?
The rear.
The rear view, okay. And you stated that you're unsure whether it was tinted?
I said the rear slightly, as far as all around, I do not recall if it was.
And you described the rear as being slightly tinted?
Yes.
So it wasn't dark?
No, it was not.
So now you stated that you observed something in his hand when you were approaching?
Yes.
What was it?
I'm unsure.
What did it look like?
As I said, I'm unsure, I just observed the object in his hand.
Okay, but in your police report, don't you describe it as a ammunition clip?
No, I did not.
So in your police report, you don't say that you saw Mr. McCall throw what you believe to be an ammunition clip?
No, ma'am.
But so your testimony today is you don't know what it was?
I said I observed the object.
Okay, can you describe the object?
I just observed something in his hand. I could not make out what it was.
Okay, and I appreciate your honesty, that's it. So at that point, you're now approaching the vehicle on the driver's side, correct?
Yes.
And isn't it true that Mr. McCall rolls down all of his windows?
Yes, he did.
Okay, and do you look inside the back window, the back passenger window, as you're approaching the driver's side?
Ma'am, I did not.
Okay, why not?
I'm on the driver's side. I didn't look into the passenger side.
Well, I'm sorry, did you look into the back, the rear passenger, the rear driver passenger side? So you're approaching from the back, you're gonna pass the back passenger. The back driver passenger, so the back seat.
The
on the
back
driver's
seat
side.
of the driver's side.
That window is down too, right?
Okay.
Is it?
I'm not too sure, but I believe so.
Okay. Now, if it is down,
Mhm.
did you look inside? Did you glance inside?
Just to see any occupants. Other than that, I'm more so focused on the driver at this point.
Okay. So, but if something was in the back seat, would you have noticed it? Let's say a gun was back there, would you have noticed that?
Possible.
Okay. So then you approach the driver's side and you see Mr. McCall, and you have a conversation with him about his stop, correct?
Yes, ma'am.
Now, you stated that you asked him if he had a driver's license, he said he didn't. And then you asked him if he had any weapons in the car.
Yes.
Why?
because my partner was indicating that he sees something.
Okay,
So it just raised the red flag, so I asked him, if he had any firearms in the vehicle.
is it illegal to have firearms in your vehicle?
No, as long as you properly.
I'm sorry?
No, as long as you do it properly.
And when you say do it properly, what does that mean?
Well, if you have the proper license to carry, then you can have a firearm.
Is there any other way a person can have a firearm in the vehicle?
Yes, you can.
And what's that?
It actually, the firearm should be in the lockbox in the rear, in the furthest from the vehicle. It should not be accessible to the occupants.
Now, isn't your testimony the firearm was located in the glove box?
The firearm was located in the glove box.
And that's permissible, correct? Transferring a firearm, you're able to have it inside the lockbox, correct?
No, it has to be in the gun box in the rear of the vehicle. The rear is as far as it can be, and it cannot be accessible to the occupant.
So you're saying that a firearm cannot be inside the glove compartment?
It cannot.
And that's your understanding?
If
Did you actually recover the gun?
I did.
Okay. Can you describe the state the gun was in when you recovered it?
The firearm did not have any, it did not have a magazine in it.
So it was unloaded?
Correct.
Okay.
But however, it did not have a magazine, but it was in the glove compartment, unlocked glove compartment.
Okay, was there any live rounds?
In the magazine?
Was there any live rounds in the gun?
No.
So was essentially the gun was taken down?
I wouldn't say taken down, but it was.
Why wouldn't you say taken down?
It was separate from the magazine.
What do you understand taken down to me?
Broken apart, as far as the slide not being on the lower receiver.
Now, what else did you recover in the vehicle?
I recovered a magazine in the rear.
And it's in the rear of the vehicle?
Yes.
Okay. Did you also observe a gun box?
Yes, I did.
Okay. And isn't it true that the ammunition was inside the gun box?
A separate magazine was inside the gun box.
Okay, so one magazine was inside the gun box.
One magazine was laying on top of clothing, and then one magazine was inside of a lockbox.
And is this something you observed for yourself?
Yes, I recovered it.
Now, I have your body cam.
Yes, ma'am.
Is there a reason why when you're going through the car, your body cam is black? I can't see anything. Did you cover it?
I did. You couldn't see when I recovered it?
No. I see the video. Everything's clear when you first approach the vehicle, and Mr. McCall gets out, but then it goes black. It's still recording, but it appears that it's covered. Did you cover your body cam?
No, I did not cover my body cam. If anything, it'd be an article of clothing, maybe. An article that I was wearing.
What were you wearing?
Maybe my bomber.
So you're saying that maybe?
I'm not too sure. I haven't seen the video, so I'm not too sure.
So, and just for the record, when you approached Mr. McCall, he did tell you that he did have a weapon in the vehicle and that it was in the glove compartment, right?
Yeah, after I asked.
Oh, 1 second, sir. Okay, so, I'm sorry. Just going back quickly to when you saw Mr. McCall throw or make some type of movement with his hands. Where, were you closer to your scout car, viewing his car, or were you up close on his vehicle?
I would say I was closer to my scout car.
So you were closer to your scout car and you were able to see clearly into his back window?
Yes, ma'am, it's a traffic stop. We just literally right behind each other within a 1 car span.
Judge, can I play the body cam? Should I disconnect to, I'll connect to phone, I think that's perfect.
Have to go on Zoom.
Okay.
And share screen.
Now, officer, did you recognize Mr. McCall? Do you know him from anywhere?
No.
Now, what's your, do you have experience with tinted windows? Are you able to tell if someone's tint is darker than what's legally required and all those things?
Yeah. Not professional.
Now, officer, is this your body cam?
Yes.
Okay. And I'm gonna play just a little bit of the video and ask you if you recognize this and if it fairly accurately depicts the stop that day, okay? So I'm just gonna play a second of it. I just paused it at 54 seconds. Officer, do you recognize this vehicle that you stopped?
Yes.
Is this the vehicle that you stopped Mr. McCall in?
Yes.
And is this fairly and accurate depict when there's the traffic stop?
Yes.
You know, I do ask to admit the special post for the next exhibit 1 into the plate report.
No objection, Your Honor.
So we're at 54, but we're gonna just back it up just a little bit. So now, is it fair to say, based on your testimony, you're outside your scout vehicle, correct?
Yes.
And this is about the view that you would have had of the vehicle?
Yeah.
Okay. And from this view, through that dark back tinted window, you were able to see Mr. McCall throw something, put his hand in the back seat.
Yes, ma'am.
We're going to play. Now, officer, how long have you been a police officer for?
Approximately 4 years.
4 years. Have you ever given anyone tickets for tinted windows because they're too dark?
I would object to relevance, Your Honor. I don't see what that's to do with this case.
Well,
Irrelevant.
Your Honor, it's relevant to the credibility of the officer stating that despite what we see as very dark tinted windows,
he could observe my client reaching back, throwing something
Well,
back.
that has nothing to do with whether or not he gave somebody a ticket to tinted windows.
Well, I asked that question to gauge his experience with tinted windows because
Doesn't
not.
matter. It's not relevant. I mean, he said what he said. He said he could see. You know, you can argue differently based on the video. It's up to you, you know, but you get to that point. The question is not relevant.
That's fine, Judge. I'm gonna play it. So at this point, you're stopping in the back seat, looking in, correct?
Actually looking in the driver. Well, from the back, I was looking towards the driver because he had not rolled his front window down.
Did not what?
So if you,
I just paused it for a minute as well, Judge.
I was looking and through the back to the driver, and I was letting him know to roll his window down, I believe. And he rolled his, as you can see, he rolled his driver's side window down. So I check if it any occupants, that depends on where I stand. Then he rolled the window down, so I stepped forward.
Okay.
So you're saying you told him to roll down his.
I did ask him to roll his windows down. Maybe not at this time, but as we were walking.
I'm sorry.
I said maybe not at this time, but from what I recall, I do believe I told him to roll his windows down.
Judge, I'm gonna pause from my questions unless you want to continue to watch. No. Okay, thank you.
Briefly, Your Honor. You stated you found you recovered the gun in the glove box, is that correct?
Yes.
So was the glove box locked?
No.
And you stated that you found other things in the back seat. You found, if I remember correctly, one magazine and one actual gun box.
Yeah, it was, I believe it was in the rear, what is it, like a hatch, basically like the trunk area of an SUV.
Understood.
So it was a magazine lying on top of the clothing, and then there was a gun box. It was an unlocked gun box.
Okay. So that magazine that you found on top of the clothing, did it have anything in it?
Yes, live rounds.
Okay. And the gun box that you found in this separate back compartment of the vehicle, did that have anything in it?
I believe it had live rounds as well.
Okay. But did it, you said it was unlocked?
It was unlocked.
Were they just loose live rounds or was there another magazine?
No, it was another magazine.
Okay. All right, I have no further questions. Thank you.
Anything further?
1 second. Just quickly, the gun that you recovered in the glove box, was it cocked back? Okay, cocked back, showing that it was completely empty?
I do not recall.
Okay, I'm sorry. Let me just, I'm gonna share my screen again, Judge. And this is Defense Exhibit 1.
Wait. Stop.
Yeah, I'm trying to, it's delayed. I've been pressed stop. I'm just trying to get to where the picture of the gun is.
Okay, is this, we still gotta authenticate, is this the same video?
Yes, Defense Exhibit 1.
Oh, okay, all right.
I'm sorry.
Coming up.
I thought I said that, Judge. Officer, so this is Defense Exhibit 1, this is the body, your body cam, correct?
Yeah.
Okay, and you know that because your name's at the top?
Yes.
Okay, and this will be,
And
this will be you going through the car,
recovering.
recovering. I press play 3 minutes and 21 seconds. Oh. Now, this is the gun that you recovered?
Yes.
Okay, and this is, so the gun is in fact cocked, showing that there's absolutely nothing, the gun is no live rounds or anything. Correct?
Yes, ma'am.
Okay, I'm gonna press play, 3 minutes and 25 seconds. Pause here at 3 minutes 40. Now, where are the pile of clothes that you testified that you saw my client?
Ma'am, as I stated, it was in a hatch. It was in the rear of the vehicle. It's like a hatch. It's like the trunk area is behind these bags.
Okay, so the trunk, okay. So this is where you recovered ammunition.
I believe I reached over and grabbed it.
Okay, so just to be clear, the ammunition, the lockbox, the other ammunition in the lockbox is all in the very rear trunk part of the vehicle.
The magazine is in the hatch, yes.
Okay. Now, of your experience, can my client while driving reach back all the way to the hatch and get the ammunition?
You asking him to speculate.
I'm asking him.
It's still speculation.
Okay.
Well, no.
Of your experience, approximately how far is the driver's seat from where the lockbox and the hatchback is located?
I don't know how you're going to answer that. Can you say that again?
Approximately the distance from where the driver's seat is, where you found Ms. McCall, and where you found the ammunition. Then the hatchback.
How far?
Yes. Can you give us approximately the distance?
What feet, inches, I don't know.
Okay, I understand.
Feet.
All right, thank you.
I have no further questions. Your Honor.
Thank you. Step down.
Thank you. And the people have no further witnesses and will rest, Your Honor.
No, Mr. Judge.
People will move for a bind over on count 1 and reserve argument.
No. No reserve argument on this. You got, you know, it's perfectly legal to transport a weapon in a motor vehicle.
That is correct.
Okay.
The issue, I believe, in this case is the biggest issue is a locked compartment aspect.
I don't think that's what the statute says. It doesn't say it has to be locked. I mean, that's what the police recommend all the time. But I don't believe the statute says it has to be locked. You gotta show that to them. It says the ammunition has to be separate from the weapon. And so that they're not accessible. And in this case, you got the actual weapon in the glove compartment, and you got the ammunition in the rear of the vehicle, trunk area of a SUV. That cannot be. I mean, Mr. McCall is tall, probably at least as tall as I am. I know I couldn't reach from the front seat to the rear of the SUV. I doubt very seriously if he can. So, I mean, unless you can show me something different.
Nope, not the judge.
Anything?
Judge, I'm in agreement with you stated. The statute does state that the gun has to either be taken down and closed in the case or carried in the trunk of the vehicle. And that was the case here. The gun was, the actual firearm itself was taken down, unloaded, no live rounds. It was stored separately in the glove compartment. The ammunition was in the trunk and also in a lockbox. And for that reason, Judge, we do ask that you dismiss the charges as the prosecution has failed to meet their burden.
Nothing further, Judge. Thank you.
All right, and so based on that, and the argument made, of course, going to dismiss this.
Thank you.
Thank you, Judge.
Need a dismissal form, please.
All right, without further
Mr. McCall, I'll talk to you later.
Yes, sure. Hey, Rob, we're gonna do,
The PCC.
we're gonna do the PCC, the sound test real quick. Okay. All right. And then we're gonna, and you see the papers, and we're gonna do that next. How you doing, Mrs.?
That's why I know kids.
Right there is fine. Call the case.
Yes. No, that's what I just
This is my first time statue. Like you said, but like you said, they recommend it. That's how. Okay, which one?
I think it's for the prosecutor. All right. Oh, this is a PCC, right? Huh? You ready, Judge? Calling case number 2356006, the people of the state of Michigan versus Noah Mendetta. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Adam Bookler appearing on behalf of the people, P862666.
Good morning, Your Honor. Vanessa Hamilton, P8107, on behalf of Mr. Mendetta, joins us in the courtroom tonight.
Good morning, Your Honor. I'm Will McGill.
All right, well, my PCC is at 8:30.
Yeah, well, Your Honor, we had this scheduled down for a preliminary exam. It might have been one of the days that you weren't actually on the bench, and it might have, I don't know, been scheduled. I can't look at the ROA, so I'm not able to confirm the dates, but we were under the impression that it was a preliminary exam, and we were ready to conduct that.
At 8:30?
At 10 o'clock.
Definitely wasn't scheduled at 10 o'clock. RA clearly says PCC, probable cause error, at 8:30. Have you had a PCC on this matter prior?
Yes, we have, Your Honor. I believe it was on March 28th.
No, that's the hearing in front of Judge Robbins on the CCW side. It's a little different.
We may be mistaken. We'd asked to set a preliminary exam date.
April 18th, 11:15. April 18th at 11:15.
Nothing from the people.
I see it was, they went in front of Roberts.
Yeah.
And they're just adjourned for another PCC. That's the. Yeah, they tried to put it.
No, I think she was also in my court.
Oh.
On that. Excuse us, Mr. Henderson, I mean, Mr. Davis.
Judge, this one is not on the docket.
Yeah.
He was taped yesterday.
Oh, you didn't show up.
Yeah.
That's fine.
Okay.
All right, can we give this to the prosecutor? I need one to the court reporter and this one to the prosecutor. This is a case from yesterday. I don't know.
Yes, yeah, we offered a misdemeanor plea on this one. Does the court have a copy of the plea form I filled out yesterday, or should I make a new one?
I do have it. I do have it. You need a copy? Do you need a copy?
I do not need a copy. I'm not sure if Judge would take the plea there, if he's going to be arraigned on bench warrant, or what's going to happen with Mr. Davis, but it was scheduled for an exam yesterday, if he wanted to. accept
Yeah,
the
he's
plea.
gonna address the cases.
Okay.
Parties ready on Larry Davis, calling case number 2355988. The people of the state of Michigan versus Larry Davis. Defendant is charged with count 1, retail fraud, first degree, habitual offender. This matter is scheduled for Raymond on the warrant.
Good morning, Your Honor. Adam Bookbub here on behalf of the people, P86266.
Cindy Henderson on behalf of defense, P84839, Mr. Davis, please state your name for record.
Larry Davis. Yeah.
All right. Mr. Davis, you were supposed to be here yesterday.
I was trying to get on Zoom.
You were set for a preliminary exam. That's an in-person hearing. There's no Zoom on that. Okay, I don't do those on Zoom unless there's some specific reason. Always done in person. Always.
I had no knowledge of that. All the information I gave, my attorney contacted me yesterday, 8 something, to say you're supposed to be reported at 9, set up the Zoom, and I was trying to get through it, and I was talking to y'all, but y'all couldn't hear me.
You weren't on my Zoom. I don't know whose Zoom you were on, but you were not on my Zoom. If you were on my Zoom, I could see you. Okay. I would be able to see you.
Yeah, I was in contact with my attorney, she kept on back and forth, she's trying to show me how to get in.
Mr. Davis, I don't care.
Okay.
Supposed to be in my courtroom at a certain time. I expect you in my courtroom at that time. Right?
Yes, sir. I have. Yes, sir. All right.
Now, get it all out. Because if you interrupt me one more time, we're gonna have a problem.
Okay.
So I'll say whatever you wanna say, just get it all out. And then that way, you know, that way I know if you interrupt me again, because you think you have the right to do whatever you wanna do. And then I'm gonna act proceed accordingly. You got anything else to say? All right. I will reinstate his original bond, personal bond. He has an offer here. He wishes to accept that offer.
Your Honor, he did wish to accept the offer in regards to bond, it was not Mr. Davis'
intent to have me address the
I've
bond.
already addressed it, I'm done with it. I reinstated his bond. What else could you want? Why would you have to argue on it?
Your Honor, Mr. Davis didn't want me to address the bond. The offer was for probation. He intended to decline the probation and take jail time until he wanted to get started doing time on it.
I can't do that.
Understood?
I don't sentence him. This, I could take the plea, if that's what he wants to do. Then he'll go in front of Judge, Brian. And it doesn't matter what he wants. She can turn around and give him jail time and put him on probation. And do whatever else she wants to do. It ain't up to him. It ain't his decision. It's hers. Just so we're clear. Now, based on that information, does he still want to accept the plea?
He still wants to accept the plea, Your Honor.
All right, raise your hand. You swear hard firm and tell the truth, the whole truth, and nothing but the truth, so help you God. I do. All right. All right, Mr. Davis, you understand that by pleading guilty, you're giving up certain constitutional rights. You're giving up the right to a trial by judge or jury. You understand that? You have the right to confront, question any witnesses the state has against you, and to use the court's subpoena power to force any witnesses you may have to come to court and testify on your behalf. You understand that?
Yes.
You also give up the right to remain silent, not have that silence used against you, or the right to testify at your own trial, if you so decide. You understand that? And you also give it, well, I said this, but I'll say it again. You also give up the right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that? You understand all these rights? You had an opportunity to go over all these rights with your attorney.
Yes.
And you freely and voluntarily waive these rights, plead guilty because you are guilty.
Yes.
Right? Is that factual basis?
Your Honor, I'll be putting on factual basis. I will be reading from Detroit Police Department Incident Report number 230315-0092 that says.
No, you won't. I get the factual basis from the defendant. You want to ask them questions, ask them the questions to give me the factual basis. I'm not going to have you read what someone else, a hearsay statement, what someone else said, and then I don't know if he agrees with it or not. He's pleading guilty, so he has to plead. I have to get it from him. Okay?
Understood, Your Honor. Mr. Davis, on or about March 15th of 2023, were you at or near the location of 18700 Myers Road in Detroit, Michigan, and Wayne County?
Yes.
And would that store be Home Depot?
Yes.
And while you were at that store, did you take property that didn't belong to you?
Yes.
What did you take?
It's just a saw, power washers.
And do you know about how much the materials cost?
Approximately maybe 9, I'm not sure.
No further questions, Your Honor.
I don't know what $9 is. $90, $90,
$900.
$900.
$900.
$900. That's fine.
May I ask one question? When you took those items, did you pass all points of sale and exit the store?
Yes.
I'm satisfied, Your Honor.
All right. Been satisfied?
Satisfied, Your Honor.
Thank you. All right, court's going to accept the plea. The matter is going to be referred to the probation department for a pre-sentence investigation report. And then it's going to go in front of Judge, Brian. Case will be transferred to the misdemeanor docket. Judge Brian for sentencing, which will be May 17th, 2023 at 9:00 a.m. All right.
Yes, Your Honor. Is there a number for the PSI or does he have to go to do that?
I'm not even sure how to do it.
He needs to wait for his paperwork.
Okay,
Yeah,
thank
and
you.
then, you just gotta wait on his paperwork.
I'm gonna get you that.
No.
Excuse me,
Judge already had.
this is your copy.
Yeah.
Oh.
Excuse me. Oh, he's on, this is
You
gonna be
pass.
dismissed.
Yeah. Huh? Deontay Foster.
Somebody put the wrong attorney.
Huh? He has a Zoom room.
He's on Zoom.
Okay.
We got going.
Calling case number 23-56080, the people of the state of Michigan versus Deontay Foster. Defendant is charged with count 1, home invasion, 2nd degree. This matter is scheduled for examination.
Good morning, Judge. Alex Lang on behalf of the people, P number P86590.
And good morning, Judge. Neighborhood Defender Service by Jackie Polkowitz, P81653, on behalf of Deontay Foster, who is present on Zoom. Deontay, will you state your name to the judge, please?
Deontay Foster.
Your Honor, with regard to his Zoom appearance, he's currently sitting in his car parked outside of 36th District Court. He has been circling for the last 20 minutes to try and find parking and has been unable to do so. In light of the fact that this is a dismissal without prejudice or anticipated dismissal, I'd ask that the court allow him to appear via Zoom for purposes of this proceeding.
That's fine.
We are not able to proceed today as our necessary witness is not here.
Move for dismissal without prejudice, Judge.
Matter dismissed.
Thank you.
Thank you, Judge.
All right, Deontay, you can sign off and I'm gonna send you your paperwork, okay?
Okay, thank you.
Yep, you can head on home.
Okay.
I know, it's watching. I know, I'm doing the most.
Can I help you, Clay?
That is my mistake. I should know better.
All right.
Where's Robinson at? We need Robinson. They're here. Yes, sir.
Robert's come in.
I think that's what he's gonna get done.
Oh. Robinson, you ready on Robinson?
They got everybody trapped down on the other side of the hallway, so they can walk through.
Judge, did you hear that?
They got everybody trapped on the other side of the hallway. What does that mean?
Yeah, they make them stop and not move because the prisoner elevator is not working. So they take somebody to the fourth floor. It makes no sense.
Yeah. Yes, thank you.
You said.
Yeah, you too.
So that's
Yeah,
what
you
you
too.
over with 2 minutes.
Have a good one, everybody.
All right.
All right.
They be telling us, don't move, don't move. They transport the prisoner. So they got everybody on the other side.
Wonder what's going on.
They ain't coming, they gonna stop them too, so.
Yeah.
Get back.
Yeah.
It takes a little bit, what do you want to say? You don't know like listening.
That's it.
Whatever happened with? Did we do that one?
We did it, Judge.
We did it?
That was that discovery order.
Oh, okay. Did you want with Bear?
Alex, I'm sorry, what is your P number?
8P86590.
Oh, it's 590.
When I don't see the P in front of the number, it like throws me off when I just go 865. Wait a second.
I know you're doing so.
Dang, they still got them locked down like that? All right, and this is Robinson. Parties ready on Edmund Robinson? Calling case number 2355985, the people of the state of Michigan versus Edmund Robinson. Defendant is charged with count 1, weapons carrying concealed, count 2, weapons firearms, possession by a felon, count 3, weapons felony firearm, count 4, weapons felony firearm, count 5, assault with a dangerous weapon, felonious assault, habitual offender for notice. This matter is scheduled for examination.
Good morning, Your Honor. Adam Bookfa appearing on behalf of the people, P86266.
And good morning, Your Honor. Madam Clerk, Madam Court Reporter, Jonathan Roberts, P86428. On behalf of Mr. Robinson, who is present in court today. Mr. Robinson, could you please state your name for the court?
Edmund Robinson.
Thank you. Your Honor, I understand, well, I don't want to get ahead of myself, but I believe Mr. Roberts has a discovery issue. We met for this exam, I believe, a week or two ago when Your Honor was out. And there was an issue with discovery, but I'll let Mr. Roberts take it.
Yes, thank you. So on March 30th, Judge Jefferson, who was standing in, signed the discovery order, which was specifically a motion to dismiss or compel, because we were missing 5 forms of digital discovery. I did receive from Mr. Bookva last week a digital discovery file. However, there were pieces missing from that. I communicated with Mr. Bookva and he tried to reach out to the OIC, who I believe was unresponsive. We did get a digital discovery file last night. However, it was after business hours and our administrator was not there to upload it. This is, now the second time that we are having a discovery issue. I fully understand it's not Mr. Bookva's particular issue, but if the OIC is not uploading things on time, it's not fair to Mr. Robinson to push this back again and again. We'd be moving for a dismissal without prejudice because the order is clear that it needs to be provided by end of business. And the OIC is not uploading it in time. He gives me time to review it and at least upload it. Then that's a discovery violation and a violation of the order.
Yeah, Judge. Mr. Roberts did indicate to me last week that pieces were missing when I sent them the initial one that I had. I did reach out to OIC immediately, and then once earlier this week, yesterday while preparing for this case, seeing it was up for exam again. I just went on evidence.com to see, and I did notice things were uploaded in the last 24 hours from that moment. But I had no idea that that actually had happened. So I sent it to him as soon as possible with a follow-up email apologizing for the situation. I will say, for the exam today, I'd be calling Ms. Jamisha Hurd, who testified to what happened to her as a civilian witness. All of the digital discovery, it encompasses the investigation that was conducted afterwards. None of it would go to what Ms. Hurd is actually testifying to today. So I would argue that we're prepared. Ms. Hurd is here. We can proceed, at least, the people can. But I understand that there was a discovery order, and I would just leave it to Your Honor's discretion with what to do with that.
Brief rebuttal.
Just to note, Your Honor, specifically what we were missing from that initial zip file was a body worn camera from the officers who responded to the scene. And they did take statements from Ms. Hurd. So we would not be ready to proceed today because I don't know what those statements were that she represented to the officers. Certainly if she's testifying today, I would need that because that could potentially be exculpatory or impeaching.
Okay, all right. You see that there was a motion to dismiss a compelled discovery filed. It was heard by Judge Patricia Jefferson on March 30th. She then signed a modified order for discovery. Although it says disclose the information no later than Wednesday, March 29th, to have that information sent over. What you said last night or yesterday?
Last night. Yeah.
Last night. Actually, is not provided. So at this point, the court's going to dismiss the case. I mean, that's not going to stop them from refiling and going through that procedure, but I'll go ahead and dismiss it. I understand the argument that you may be able to put forth the elements based on the witness, but the witness also made statements to the officers on the video, and that precludes the defense from being able to adequately cross-examine them.
Of course, Your Honor.
So, of course, going to dismiss the matter without prejudice.
Thank you, Judge.
Yes, Your Honor, thank you. Wait outside the attorney. Robinson.
Yeah, I'm doing it.
She had to cancel the warrant first.
Yeah, I'm sorry, I had to cancel the warrant.
Don't be rushed by court officer. Also, the warrant.
No rush, no rush. Mr. Cohen checked in.
What time is this?
11:45. So we got time.
He doesn't expect this one.
Open skip.
Yeah.
How you been, Mr. Roberts?
Doing well. Celebrated Easter in New Orleans, which was nice.
Oh.
Yeah. Did you get some videos?
More than beignets, but it was nice.
Yeah, maybe that's what you want to do. Did you try the oysters or anything?
That's in process.
Now, like, Charlotte rural places.
Yeah.
Okay.
There's a place on Athens, it's a good restaurant. And the people, yeah, it's. We were running hot too, right? Nice and warm. Like, yeah, nice and warm.
Good to see you, Judge.
So, Quinn. Tell him to get it. He said, yeah. What you got?
So nice outside. Thanks.
I hear you.
Hey, Judge. Good, how are you? Great. Look like a real judge there. He's looking like a real motorcycle guy. And his vest. Oh, you rode your And his Judge? glasses and the, all this black. And he's looking like a bona fide bike rider. Biker. That's what I'm
But yeah, no, I want to be here.
No, I still don't see none. Did you send it to me or to the courtroom email?
I think he's sending it to you, he might have misspelled it, so we're just gonna send it again.
Yeah, I'm also wondering. Sorry, you're funny looking me.
It's different, I was just funny.
Are we ready on Curry?
Yeah.
Yes, defense is ready.
Calling case number 1263186, the people of the state of Michigan versus David Curry. Defendant is charged with count 1, police officer assaulting, resisting, obstructing. Count 2, assault or assault and battery. This matter is scheduled for examination.
Good morning, Your Honor. Adam Bookfoot appearing on behalf of the people, P86266.
Good morning, Your Honor. Neighborhood Defender Service by Jonathan Cohen, P86151, appearing in person, requesting to waive Mr. Curry's appearance for today's purposes.
Make an exam.
I understand, Your Honor. There are
What
extenuating
basis could you have to waive his appearance for a preliminary exam, which is a substantive hearing that he has the absolute right to be?
Your Honor, I'm requesting to waive his appearance for purposes of today because it's my understanding that there may be a motion to dismiss by the people.
Yes, Your Honor, this is a 2012 case. I was unable to find any discovery, none exists. If Your Honor would allow me to nully cross the case without Mr. Curry being present, then I would do that. But if you need Mr. Curry here, then we can go the capious route, whatever the court
Need
wants.
Mr. Curry here.
And
I mean, if he was on Zoom or he was in a hospital or, something like that, I can get away with it, but, he's just not here.
And I will share information with the court. We have been unable to achieve contact with Mr. Curry, neither phone nor letter. I actually sent my investigator, Yusuf Yokana, out. He went to multiple addresses that we had historically for Mr. Curry, talked to a couple of his family members who indicated that he's been off and on homeless and also off and on hospitalized recently, having been released from DMC a few weeks ago. Family doesn't know where he is. They've been trying to get in touch with him. There may be some mental health concerns. My concern, it's not a concern, just this case, it doesn't seem like we'll ever be able to be prosecuted. And so he might get picked up on a warrant at some point, but it will ultimately, it seems, be dismissed if there is no file anymore. So that's the basis for my request. I totally understand the court's position with respect to Mr. Curry not being here. But if this ultimately will be dismissed, that's why I'm asking for the court to forgive his absence today.
The mental health issues are extenuating enough to. No use in so, you want to know the process?
You would permit it, Your Honor? Okay, then the people will move to dismiss this case, Your Honor, for insufficient evidence.
All right, the matter is dismissed.
Thank you, Your Honor.
No, thank you. Doesn't need a dismissal.
You got a dismissal?
Yeah.
I don't know his date of birth because I don't have it.
That's
So I don't know. I filled it out to.
It should be in the box.
Sorry.
What?
All time. Like you challenge, right?
Get anything wrong with that past 30 years.
Oh, yeah, it's mine. Oh, but it was over there for the prosecutor.
You want to keep the prosecution?
Yeah, just keep it on it. They had it on the glass.
Oh, okay,
Just in case they needed it.
was that a dismissal?
Yes.
Cool. You know what you need, one more cage.
Yeah, I can use minutes.
Right.
All right, last one. There's only one charge in there. There's only one charge in the system. Yeah, we only, yeah, it's only one. All right, thank you.
We don't have an attorney. Hey, who's Johnson on that case?
Huh?
Who's, Attorney Johnson, which one is that? Dustin Gregory Johnson? That one?
Dwayne. Yeah. Yep.
Who's outside?
Yep, that's Dwayne.
Okay. Yeah, also. Yep.
Bring my file.
We'll find out.
Speaking out loud, kind of sort of.
Yeah, so we got Frank out for. We need to get in touch with Mr. Johnson. His client's not here.
Is he on Zoom? Is his phone number in here? Yeah.
Mr. Johnson?
Yes.
Good.
Nathan Kelps, I'm an intern in the call. I came to observe. Go ahead and do that. Is that what you're looking for? He's an intern. He's just one
For cold, right?
Yeah. Yep.
It's not weird. He wants you some cases, we ain't got that.
Yeah, you're not gonna.
But you can go to the fourth floor, probably.
You came to the right, group prosecutors.
That's what I've heard. That's what I've heard.
You heard this already?
Yeah. I graduated my. I was just looking for it, and they were like, yeah, you observe it. I was like, wow. All right.
That's weird, we're the attorney and.
Yeah. You see.
Hey, how you doing? Yeah. I'm also an intern. And then you want to. Oh, I'm not. You're Yeah. Yeah. I would graduate. Yes. Yeah. What's the?
Oh, yeah.
Yeah.
So,
Well, I have no idea. Oh, what's it?
I mean, I've been practicing.
That's right. I didn't. No, I just came down here like. Oh. Yeah. So we should try. Oh, tomorrow? Okay. Yeah, that's what I thought, yeah.
I think I've heard that before.
Like you said, PCCs are on Zoom.
Oh, okay.
Yeah, the exams are here. It's a waiver. Okay. And Judge Giles, he's a Wayne State grad.
Oh.
Yeah,
yeah.
So he wants to come tomorrow. He's from Cole. He's practicing with
Hi,
Cole.
Judge. How you doing? How's it going?
He's practicing with Cole. He wanted to see how Wayne County does it. Hearing that you was one of the baddest guys in town. So we just, and we was the toughest courtroom. So he wants to come and see it tomorrow, probably.
Everyone tells me crazy things, so I have to come down here.
Yeah, we
See
gotta
the
find
other
out
side of
there.
the rest, so.
All right, where's Mr. Johnson? Huh? Nope, that's why I don't seem right.
I'm trying to get out this week, so that.
Yeah. She's all in Jefferson.
Huh?
Jefferson did it. I don't see how he confused. Hold on.
Who was that?
Dwayne Johnson.
He had the car, right?
It was when Judge Jefferson did the PCC.
Tomorrow. Is that Mr. Johnson?
Yes, sir.
Ask him to come back in.
Okay.
Please.
Oh, that's him?
Yes, yeah.
Oh, okay, cool.
Mr.
No, I called, I left a message. He didn't answer.
Johnson,
Oh, let's see.
have you talked to your attorney?
Yes,
When did you talk to him?
he called me and made sure, I just got off the phone with him probably like 20, 30 minutes ago. He said he's down here at 12.
Oh, so maybe he's out of the way.
Also, would you mind calling him again, tell him he needs to be here?
I didn't know we couldn't bring our phones in, so I left my phone in the car.
Oh, all right.
I'll see if I can.
Oh,
That's
here,
it, right?
Yeah, there you go, right here.
Sorry.
We're ready. Oh, okay. Step right over here. You're gonna sit right here. As soon as you call the case, you can stand up, all right?
Waiting on you, Mr. Johnson. Waiting on you.
Right?
We was waiting on you.
Oh, okay. Judge, sorry, I'm still ready to send us out. Oh, okay. Sorry, about that. Got a little tired up.
Calling case number 22-59585, the people of the state of Michigan versus Gregory Dunson. Defendant is charged with count 1, controlled substance, delivering, manufacturing cocaine, heroin, or another narcotic less than 50 grams. This matter is scheduled for examination.
Good morning, Judge. Alex Winter on behalf of the people, P number P86590.
Good morning, Your Honor. May it please the court, Dwayne Johnson, P41842, on behalf of the defendant. We're ready to proceed.
Mr. Johnson, state your name, please, for the record.
Gregory Johnson.
All right, thank you. Ready to proceed?
Yes, the people are ready to proceed. Call our first witness, Trooper Jake Yukon.
YAC.
Well, that's right, please. You swear hard or truth, whole truth, and nothing but the truth, so help you
Yes, sir.
God. Well, have a seat, please.
Good morning, Trooper. Can you state your name for the record?
Jake Yacone.
What is your occupation?
I work for the Department of State Police,
And how long have you been employed there?
about 7 years.
Were you working on the date of September 3, 2020?
I was,
Did your work bring you to the location of Woodward Avenue near State Street, Detroit,
it did,
County of Wayne?
correct.
What did you observe that day?
That day I observed 2 infractions. One was out taillight passenger side on a Charger, and then while running the registration plate, no return.
What did you do after you saw those infractions?
I conducted a traffic stop near the location.
When you conducted that traffic stop, what happened next?
Spoke to the driver. Driver was unable to provide an operator's license, so I requested he step out of the vehicle, which he complied due to misdemeanor offense.
Did you talk to anyone else in the vehicle?
I did.
Who did you talk to?
Front seat passenger.
Do you see the front seat passenger in here today?
I do.
Can you identify a piece of clothing that he's wearing today?
It's the gentleman wearing the black shirt.
Please let the record reflect that the troopers identified the defendant. So after you made contact with the defendant, what happened next?
Asked the passenger to step out of the vehicle, which he complied.
When he stepped out of the vehicle, what did you do?
I requested his identification. I can't remember if it was an identification card or wrote it down, and then conducted a lean NCIC check on his identity.
What did that check come up and show?
It advised that he had warrants out for his arrest.
During that check, did you do anything after that?
After that, I placed him in handcuffs and searched his person.
When you searched his person, was there anything on him?
He had a bag draped over his body. I opened up the bag and observed 2 prescription bottles without labels.
When you saw those prescription bottles, what did you do?
I secured them and then conducted an investigation further at the Metro South Post.
Did you ask him if he had a prescription for those?
I did at some point in time. I can't remember if it was on scene or in the patrol car.
And what was his response?
He advised he did not.
Did you put an evidence tag on those pills that you found?
I did. I seized them.
What evidence tag did you put on those pills?
Evidence tag 2 and 3 were utilized for the prescription drugs, the Schedule 2 narcotics, and then evidence tag 1 was used for a large quantity of currency that he had on this person.
People move to meet proposed exhibit 1 pursuant to MCL 76611B, the Department of State Police Forensic Science Division lab report.
Show it to Mr. Johnson.
Can we get to your register?
Good. All right, in a minute.
So I'll just be reading the relevant portions.
No, I don't need you to read, I can read myself.
Okay.
You a minute. I can read it.
Can I have permission to publish?
Sure.
Okay. May I approach the bench?
Yes.
Yeah. So how many pills did you recover as well?
I don't know the exact number. I would have to look at the police report to be sure.
Can I approach the witness with the police report?
Fine.
For the exact pills?
No.
Okay. Did you recover anything else besides pills?
A large quantity of cash, which was logged under property number 1 in my police report, sir.
If I showed you a copy of your police report, would that refresh your recollection?
Yes.
We'll allow it this time. He didn't say he needed his recollection refreshed. You're supposed to ask him that question in the first place.
Yes. Thank you, Your Honor.
As to the pills, the same thing.
Okay.
You know, that you ask, you want to show him pills, you want to show him to refresh his recollection, not to testify how many pills. You understand?
Yes.
Okay. You can approach.
Can you say how many pills were in there now?
Approximately 66. It was a mixture of oxycodone and
Alleged
oxycodone and methamphetamine pill.
And then approximately what was the cash that you saw too?
What was the what?
What was the amount of cash?
it's over $6,000. I don't know the exact amount, I'd have to refresh my memory again, sir.
May I approach the refresher's recollection?
Sure.
What was the amount of cash?
$8,042.
Thank you. After you seized the drugs and the cash, what did you do next?
I advised, the suspect of his Miranda warnings and, at some point in time conduct an interview on the way to the Metro South Post.
What were the pills that you recovered when you ran? Did you run any tests or anything on scene?
I ran them through pill identifier.
And when you ran for pill identifier, what did they come up as?
It advised that the markings on them were oxycodone and, methamphetamine pill, Advil of some sort.
No further questions.
Good afternoon, officer.
Good afternoon, sir.
So were you the driver of the scout car, or were you by yourself?
I was by myself, I was the driver, sir.
Okay. So you stopped the car that my client was in, for what reason?
Due to the passenger side brake light not illuminating, it was somehow malfunctioning at some point. And then when I conducted a registration plate, so the registration that was attached to the vehicle was a temporary registration. The return indicated that it wasn't registered to that vehicle, there was no return on it.
So you did that before you actually stopped the car?
Correct.
So you stopped the car, you talked to the driver of the car, and found out there was some irregularities, he didn't have his driver's license, or what was it?
Yeah, he wasn't, his operator's license wasn't valid in the state of Michigan.
Okay, so did you arrest him for that?
I had him step out of the vehicle, it's a arrestable offense in the state of Michigan.
Pardon?
During this incident, I just wrote him a citation due to the arrest I already had, I can't transport it to.
Okay, so he was able to drive off, is that correct?
I can't remember if he drove off or if I towed the vehicle.
So my client's on the passenger side.
Correct.
So why did you have to talk to him?
I just requested him to step out of the vehicle, which he did, and spoke to him.
Why did you request him to step out the vehicle?
Just to have a conversation.
Okay, were you basically forcing him to step? You felt like that was you giving him a command to step out the vehicle?
No, I never forced him.
So he could have just stayed in the car and not responded to you, is that right?
Well, if, I can't remember this exactly, but it's a arrestable offense to tow the vehicle. I can ask the passenger to step out, do the inventory search as well. But during this point in time, I just asked him to step out, sir.
I mean, you don't remember if you impounded the vehicle or not, right? So you weren't even at that point yet. When you went to my client, you told him to step out the vehicle, right?
I'm going off of my normal operating procedures. I can't remember a date back in 2020 exactly, but this is how I always conduct my investigation, sir.
Okay, so you had him step out the vehicle and you started asking him questions, is that correct?
I requested his identity.
And he gave you his name or?
He did.
Okay.
I can't remember if he gave me his name or identification card. I can't remember exactly, but I obtained his identification somehow.
Okay, and then you said he had a purse on or a purse in the car?
Like a satchel, like a bag.
So you began after you had him step out the car and gave you his name, that's when you began to search the pantry.
Now I conducted a lean NCIC check on the identification your client gave me, and it indicated that he had warrants out for his arrest. So at that point in time, I arrested him on his warrants.
At that point, you arrested him on the warrants, and then you began to search the patch or person.
I conducted an incident to arrest search and a client search.
And you're saying he was arrested for warrants? That was what he was arrested for?
Correct.
Speak to my client. Okay, so in the purse, you say you found, what did you find in the purse?
Prescription bottles without labels on them, and then a large currency of money.
Okay, and you said the amount of money after you refresh your memory was about $8,000?
Yeah.
So do you know what happened to that money?
It was seized by the state police, and all the paperwork was sent over for forfeiture to the prosecutor's office.
My client was getting paperwork concerning that as well?
Yes.
I'll let him do the question.
I have nothing further.
Thank you.
Thank you, Your Honor.
No further witnesses.
No witnesses, Your Honor.
Argument.
The people move to motion to bound over on count one. We see here that the defendant, in the amount of quantity of pills being asked, do you have a prescription? There's no prescription. In the amount of cash that the defendant had at him, over $8,000, containing the pills that, as you can see from the lab report that was admitted as an exhibit. The preliminary testing shows presence of oxycodone, oxycodone, a Schedule II controlled substance. This shows the people have showed that the defendant was delivering with the quantity of pills, no prescription, close to 8,000 cash. The people have found that they have proven this burden of probable cause. Motion to bound over on count one.
Not how he opposed to find over. First of all, there's no evidence that he was delivering anything. There's no evidence of that. But also, I feel that the search was unconstitutional in the sense that my client simply in the car, there was no reason to even approach him to try to get additional information, have him step out the car and try to get information about him. There was really no probable cause or reasonable cause to do that. He didn't indicate anything about officer safety or anything of that nature. So we would say that it was an unconstitutional search, and that is, for that reason, the matter should be dismissed.
Your Honor, again, I'm out of the car when he saw that the warrants for the driver, and then he sees that the passenger has warrants as well. That is not an unconstitutional search. And also we can see that when the defendant was asked again the prescription, he had no prescription, and he's carrying large quantity of pills, and he's carrying large quantity of cash.
All right, court having heard the testimony, arguments, finds them followed. On September 3rd, 2020, and Trooper Jake McCone, Michigan State Police, was on patrol in the area of Woodward near State Street, observed taillight out in the registration on a vehicle, did a traffic stop. Approached the driver had no driver's license. He asked the front seat passenger to exit. He identified the front seat passenger as the defendant. He asked the defendant for his identification. He was either given ID or his name. The lien check came back, there was warrants, placed him in cuffs. On his person, he had some kind of bag or satchel. Inside, there were 2 prescription bottles without labels, approximately 66 pills. Did a preliminary testing, came back for oxycodone pills. I mean, the number of the pills, I mean, if it was 3, 4, 5, 9, less than 10, anything less than 10, probably can go with personal use. But 66 pills and $8,000 suggestive of delivery. At that, it's a question of fact ultimately. So I find that the complaint enumerated complaint warrant that in fact occur in the city of Detroit, probable cause exists to charge this defendant, will be filed over Wayne County Circuit Court Criminal Division for arraignment on the information, which will be April 26th at 9 o'clock.
Thank you, Your Honor.
Thank you, Judge.
Thank you. Anybody else have to do? It's good seeing you. Yeah, good seeing you. Yeah. No, just over the date. Right. You need anything? Oh, sure.
Everybody have a good day.
All right. Take care now.
Vote for You got 4 prisoners.
You don't have, you can connect this.
Okay.
I know. Okay. So, you know, because it's
Oh, you.
you're gonna use the lab report, and you gotta connect this.
Oh, yeah.
Number, number 2.
Yeah.
I said.
I see.
Yeah. 3, you have.
Wow.
Yeah. One more.
I think I took it all.
Okay. Yeah.
Just fine. Yeah. That's how I want you to understand.
That's deep, man.
Yes.
So. Do it next time, we got to make sure. This number.
Exactly, that makes sense. Thank you, Judge.